Very well. How are you doing?
So as we take our seats and look forward to the next panel, I just wanted to make a quick PSA for a new initiative that's coming out of the Codex Blockchain Group, co-chaired by Tony and Kush. One of the things that obviously a lot of folks are looking at is the regulatory environment. We're going to be kicking off a forum utilizing Chatham House rules to engage technologists, folk builders, basically academics and people in the area with regulators, with policymakers. We're calling it RegTracks, and we're going to be kicking off with a virtual forum that's going to be kicking off in mid-April. The goal of this is to start having frank, open, and informative conversations about issues, opportunities, and frankly, choke points on regulatory frameworks in the blockchain space. So look for more of that. We're going to be sending it out. Rianka, Ruben, a number of folks are going to be working on that, and that's coming up starting in mid-April, and it's called RegTracks, and look to see you online.
Yeah, please just get in touch with Michael or Ruben. Ruben, are you in the room? Yeah, Ruben, if you're interested in participating in that, again, we're going to have some experts, both in terms of regulatory as well as legal counsel, as well as innovators themselves, in a Chatham House rules environment so that they're able to speak more freely. But we invite people who are interested to participate by essentially being on the email list and essentially, the Chatham House rules are going to be enforced on an honor code basis, just no cutting and pasting, and there's going to be proceedings produced of that email exchange afterwards. So we're going to do that, an experiment to try and, again, bring this sort of global community, this coherence amidst potential diversity, given the fortunate position we're in to be here at the heart of a great law school and also a great technology ecosystem. So thanks for that, Michael. Turning next after what I think agree was a really wide-ranging and sort of rigorous discussion there. Thank you, Stephen. I'm going to turn now to our four wonderful panelists here. They're each going to present for a few minutes just on a particular aspect of what Enterprise Council need to be considering when it comes to blockchain. How and why these are going to enterprise their day-to-day lives. Some of this is going to flow into some of the other sessions as well, but really this was trying to focus very much upon those sort of real nitty-gritty issues that Enterprise Council are being expected to deal with. So I'm going to allow everyone to introduce themselves, but just as a very quick overview, Daza, MIT Media Lab, legal engineer, I'd say chief legal engineer there, and he's going to give a high-level overview of some core enterprise sort of considerations for blockchain. Silke is the general counsel at Gnosis, which is a blockchain company that's, and I'll let her introduce that, but we're very proud that she is a Stanford alum and has returned here to share her insights with us. Then we have Professor Andov, Alexandra Andov, who's flown all the way out from Copenhagen to be with us here. So we're really, really delighted to have as I said, a global community who's willing to join us here. Professor Andov is an expert in corporate governance, and she's going to be addressing some of those governance issues from within the enterprise context and how blockchain plays a role. And then Brian Tang is not only experienced counsel, he's also a legal technology innovator, really a counterpart, and I like to say I try to wingman him in what he's doing in Hong Kong. And so he's based at Hong Kong University. He's done a whole bunch of blockchain implementations in financial services from an enterprise context, and has been doing some prototyping with smart contract tools with various communities, students, as well as entrepreneurs in Hong Kong as well. So he's going to give us a bit of that. And then we'll have, again, another broad-based discussion around these issues, very much open to all of your input as well. So with that, I'm going to hand it over to Daza to give us some overview of enterprise concepts.
Okay.
Actually, you've got that.
I do, yes, thank you. Picking up from the through line from the last session of the observation that on the one hand there's crypto crazy, and the other hand there's legal absolutist, and the prescription was some have these in a dance and to be adaptive to one another and to find our way forward that way. I want to take this moment to look at it from the perspective of legal maximalists and what might it look like from the current terrain to begin to adapt to these new technologies and new processes that are available with distributed systems and with blockchain and DLT technologies. So the three things I want to highlight are, number one, a relevant dimension of the existing legal framework, specifically in commercial law, so at the edge points between one enterprise and other enterprises, or that sort of system boundary between whatever the enterprise is and things outside of the enterprise and the inputs and outputs to it. The second thing, okay, so on that first one, the law that I think would be worthwhile to look at to begin adapting from, it comes from UNCITRAL. It's the model law on electronic commerce, and it's enacted in the United States at the state level through the Uniform Electronic Transactions Act, at the federal level through e-sign, the e-signatures and Global and National Commerce Act. The best of that statute is that it, first of all, grants legal equivalence, basically, to electronic contracts with paper contracts, and electronic signatures understood broadly in terms of technology with manual signatures. But also buried in there, if you dust it off and take another look, it is a nice treatment of automated transactions and electronic agents, which is one way to describe some of the functions and dynamics of these blockchain-based systems. The key, having been to every drafting meeting over 2 years for UITA, I remember painfully vividly that one of the main balances in recognizing and providing the legal equivalence for automated transactions and commerce conducted through agents, making that valid and enforceable, was this concept that at that point we called attribution. So if you read through the definitions and the section on attribution, it basically describes some standards by which one must attribute the actions of electronic agents or other automated systems to legal parties. So the basic idea was that legal parties are responsible for and also have the right to the benefits of the activities that occur through automated systems that they deploy. So this is definitely not the perspective of let's give AI or DAOs legal personality or treat them as a legal entity. In some sense, it's the side of legal absolutist. However, some of these rules are very flexible and can be applied and adapted in ways that embrace the existing legal frameworks and also provide a basis for predictable legal results while using these more automated and increasingly autonomous systems. But the trick is, from an existing enterprise kind of perspective, to come at it with a priority of understanding who the other parties are in the system. So this is not, so from an enterprise perspective, engaging in anonymous transactions isn't a perfect fit, but it is possible to link parties that enterprises have contracts with, suppliers and channel partners and customers and other business partners to blockchain addresses and to identify certain types of transactions that are happening under existing relationships as happening through these services, and to have the rights and responsibilities and the legal relationship in existing contracts apply to conduct through these other systems. And that brings me to the second big point, which is enterprise systems. When I was practicing law, I really cut my teeth as a technology counsel in big enterprises. And from that perspective, the legal architecture for big enterprise systems is kind of frequently, when you're dealing with a bunch of enterprises, there's like 3 layers, especially in transactional systems. One layer is like the high-level rules, the umbrella rules of the system that you're all engaged in. some contract that every party signs, and then a bunch of transactions. So if you think of credit card system or other financial systems, there's like the SWIFT operating rules, there's the Visa operating regulations. It's like this overarching set of rules. Same in supply chain. There's like a trading partner agreement that governs the whole system. And then there's each party signs a participation agreement, like I'm going to be an acquiring bank and I will abide by these rules, or I'll be a supplier, or I'll be a buyer in the supply chain, and that gives these rules contractual enforcement. And then under these two layers of rules, you then can do a bunch of transactions without having to have a big contract for each credit card transaction or each invoice or sale in the supply chain. All those high frequency transactions can occur because you've got the higher level set of rules. I think this 3-layer sandwich is worth looking at and adapting and applying forward into DAO transactions as well, DAO and other blockchain and distributed ledger transactions. I think the creative lawyering will need to be asking questions like, where does it fit in our kind of legal stack? And then the other question will be, I've written quite a few of these kind of system rules. Usually there's an order of precedence that people argue over. So especially from an enterprise context, when you're looking at agreements with other enterprises, it's very common that these enterprises have multiple agreements from different parts of their enterprise or different types of products and services and different activities they do. They usually have a number of different agreements. No one of them contains all of the rights and obligations of the parties. And so best lawyering practically is to identify for any one of these agreements which other agreements take precedence over it and which ones will be kind of eclipsed by it. So in other words, which rules will govern in the event of a conflict between this set of agreements between enterprises and that set of agreements. That would be a real good place to start looking for when enterprises begin adopting distributed ledger technologies, blockchain systems to do business, and for them to get explicit in their existing contracts about where those, what rules will apply to those interactions, and which will take precedence over which others. This is sort of a practical, almost like Tony was saying, an engineering mindset to constructing legal frameworks for these technologies. And then finally, I'd say that I think the concept to look at isn't so much enterprise, but it's actually the sort of sub-thread when you have what we used to call extended enterprise, because there's blur at the edges of an enterprise system. It's not all just your HR system and your catalog and your things. There's a lot of integrations, and sometimes the extended enterprise can be hard to draw a precise boundary there with all of the integrations that we have. So there's a term in the late 90s that it may be worth resuscitating. It was XBI. I forgot what the X stands for. I think it was like the X. Yeah, it's extensible in XML. I think this was basically the concept was extensible business integration. That's what XBI was. And so the concept was what we need is this almost sort of like membrane that people can easily opt into, where we have a kind of system of systems that creates a kind of meta architecture. So I think where we ought to be looking next for applying these technologies in an enterprise context is to think about what the new community rules would be, whether they be founded in MOUs or in master contracts or in things like umbrella agreements that we have in exchanges and supply chains and other federations now or elsewhere, and making sure that people understand what rules apply and how it fits in the rest of their architecture. And the challenge I would provide on handing off is, instead of thinking about bilateral contracts and multilateral contracts, why don't we think about what if these agreements were interlateral, in the sense that it would be possible for some of the terms to actually be dynamic and be incorporated by reference based on the then current schemas or rule bases of systems that we choose to interoperate with, just the way when we do an OAuth token or some other simple kind of like REST interface integration. There's some kind of developer agreement. There's some rules that you can choose to agree with, and then basically in a permissionless way integrate with your systems. This would be a primitive way to think about interlateral rules. Maybe there's some more structured enterprise thinking to consider how you can have almost like folksonomies of rules that can be evolved over time, but can still be clearly incorporated by reference as we start connecting our systems and letting them evolve. So there's my best shot at taking it from the most boring possible enterprise, like legal absolutist position, and starting to take a nod or like a blockchain curious perspective toward taking steps into the unknown from where people are today. So.
And just to be clear, in terms of how we see these multilateral stakeholder frameworks sort of being appropriate and relevant for Enterprise Council to be aware of, it's because they provide a interesting precedent of what has come before. And the building blocks of what went into those are already grokkable in a sense and should be more familiar, and therefore a great way, an entry point into understanding the different pieces and concepts.
Yeah, precisely. So as I understand it from our meeting before the panel, like one of the mantras is, there's fear, but we've been here before, and so let's move forward together. So I'm trying to supply the we've been here before part of that, and to take a look at what existing frameworks exactly, which are familiar to people. Part of change in migration and enterprise is technical, and some of it is legal, but it's fundamentally social. Like people get freaked out by a lot of change at once. So there needs to be a migration path and a change management path to get people used to it. And starting with some familiar patterns is one path.
So that was Daza with the warm and fuzzies. Thank you, Daza. Now we're going to shift modality entirely, and Silke is, I don't think, going to be warm and fuzzy at all. So, Silke.
So I'm the Chief Legal Officer of Gnosis. Gnosis, I wanted to explain a bit more what Gnosis actually does. So we're a blockchain venture. We're building infrastructure on the Ethereum blockchain. The motto is to distribute the future. So it's really infrastructure. So what we're building, well, you can create tokens, and it's creating conditional tokens is a prediction market platform. You can trade those tokens. We have a protocol, exchange protocol, which is using the Dutch auction mechanism to prevent things such as front running and to give more freedom to the user. We also allow you to hold tokens through the Gnosis Safe, which is a self-custodial multi-signature wallet. We also have an older wallet, the Gnosis Lite wallet. It still currently holds $2 billion. It's heavily used by the industry. So what I wanted to say is that also we're bootstrapping the DAO to, at the moment, to govern this Dutch auction exchange. As you can see from that is that we need a lot of lawyers. We have a lot of products. So I was asked to speak a bit more about how what I expect from the lawyers, and actually, Daza, you brought it up really nicely. What we need is this engineering mindset, or this legal engineering mindset from our lawyers. And I think what needs to change, for us actually to change or to adapt this legal framework, what is necessary is that the lawyers understand those frameworks. And without them understanding it, we're not going to get anywhere. We're just going to stick with this kind of intermediary system where you have attribution and agency, but we will not give legal personality to DAOs, for example, which I think is actually not even such a radical idea. So I think I can speak about what I want for blockchain venture, what kind of lawyers we need, because I worked in legal practice for 10 years and then moved to Gnosis, and we have, as I said, lots of lawyers. What I noticed is that we get these legal memoranda from lawyers, and these legal memoranda, they make all these assumptions, and it's obvious why they do it, because of course they need to hedge their bet because the legal framework isn't ready yet to do anything better. But that was actually a reason for us to move lawyers in-house, because we need real opinions on things. We don't just need legal memoranda that discuss a lot of, that give us ambiguous advice. So my opinion on this is pretty unpopular, at least in Europe. I really think that, okay, for me, I'm a lawyer, so my coding skills are pretty bad. I did maths as undergrad, but that doesn't get me anywhere. But I think in the next 10 years, the lawyers that come out and deal with these things, they need to adapt to the technology, and they actually need to be able to code. Because what I realize is that when we deal with lawyers, and if they don't have at least a basic understanding of how things work, it just doesn't get anywhere. So I want to put that out there, because we had it in the previous panel, and I think this is, for any lawyer who needs a future law conference, mathematics. So people might not be good in maths, but they still know a little bit of maths. They know how to add things together. They know how to deal with this. I mean, this must be the same in the future for us lawyers. You need to have a basic understanding. If you work in blockchain, you need to know how things work, how the Ethereum blockchain works, and how to a little bit about the language of things. And I think while we haven't been really skilled in this, and it's difficult for older persons to adapt, at least this should be what is the case in the future. So the moment we have that, I think it will become much easier for us actually to develop a regulatory framework that is suitable to what we are doing. So I think that's where I leave it at.
Amen. Maybe so.
Alexandra, if you wanted to maybe make the case for or against lawyers needing to learn to code, but but speak also, I think, in the context of your expertise around corporate governance as well in blockchain.
Thank you, and thank you for having me. It's really great to sit in a panel where at least we agree on 80% of the things, and how we see also the legal education. Although, so I think one problem there is that majority of my classmates, at least 15 years ago, decided to study law because they suck in math. So that might be a little bit of challenge, and please don't use the language in the translations.
It's a technical legal phrase, right?
Okay,
Yeah.
Yes. So a little bit lighten up the conversation. So my background is that currently I'm an assistant professor of corporate law at the University of Copenhagen, and I try to bring all these kinds of conversation in, both from the perspective of research and from the perspective of education. And as we talk about the enterprise kind of perspective and experience, my first experience with blockchain was several years ago when I was still a corporate counsel and actually working on white-collar crime cases, and saw a swift kind of a move from using Russia as a country where the money disappeared, and instead using Bitcoin for making money to disappear. So that was a little bit of a negative connotation in that regard. And I think this should be borne in mind whenever we talk about technology, is that what is the value of the technology and what it really brings to the enterprises? Because sometimes I'm afraid we don't really have the answer to this, and yet we become very much thrilled about the new technology and want to push forward without really considering, okay, and what now, and why we're actually doing this. And the second is the real misuse of the technology and the blockchain in regard of the cyberspace and how we are going to enforce certain things. So I think this is also something to consider. I was asked by Tony to come here and a little bit talk about the project that I'm currently carrying out, which is looking at the blockchain from the perspective of corporate governance. And this is a part of a larger project where I'm trying to assess to what extent can technology bring trust in regard of capital markets, and whether first of all, it can even bring the trust to the capital markets. I'm looking at it from a slightly different jurisdictional angle, and that's the European Union, where we are still struggling with a proper functioning capital market. So whether the new technologies can actually boost this part of the market. So my project and the article that I'm working on and should be published with the Cornell International Law Journal is on the using pros and cons of using blockchain for corporate governance. And there are certain, I would say, pillars where blockchain could contribute, whether it is the kind of a more transparent overview of the ownership, permitting real, visible, real-time observations of different kinds of transfers, the fact that the stock ownerships would be constantly updated, and this accurate record of ownership could affect also the number of market externalities and the behavior of hedge funds or activist shareholders. On the other hand, in European Union, where there is much more support for, let's say, smaller shareholders support their position within the governance and also fight against different kinds of manipulations that are part of the everyday behavior on the market. Then the second pillar would be connected to the general meetings and information and participation of the shareholders, which goes hand in hand with, okay, can we use this technology to really communicate better? Or is it, again, something that we put in between the people and the communication actually suffers due to the technology? Or whether the infrastructure could help the governance at the end of the day. And then the bigger picture, and also this is something where I would be very much happy if you would share your perspectives or opinions, is whether we could cure with the technology the shareholders' apathy. Whether this is something that we can either build new types of governance structures, more democratized ones, could we use it in some other models? Of course, there are many considerations. I'm just bringing it up as whether we can empower ultimately the shareholders. From the experience perspective, Tallinn in Nasdaq Tallinn in 2016, they were pushing for, or they announced their pilot program for blockchain voting. They're still somewhere in working, as we know that the technology is still developing. But yes, so I do think that blockchain is definitely an extremely interesting technology. But at the same time, I just wonder what Daz was talking about, the legal architecture. Looking at, let's say, 2-3 jurisdictions that are currently considering heavy blockchain regulation, let's say Switzerland and Liechtenstein. And if you look at the approaches, some of them are unfortunately only published in German, but some of them, at least some brief overviews, are also available in English, and I would definitely urge you to have a look at them. You see completely two different perspectives and approaches to regulation. In Liechtenstein, you see a new law on blockchain. There would be a general law that could apply on anything. Whereas Switzerland, at the very beginning, in September or October last year, there was, okay, this can be the way how to do it. But later on in November, they came to conclusions, maybe this is not the way. Maybe we should just put different kinds of aspects of blockchain in all other our existing laws to support and somehow also this correlates, I think, to this infrastructure. And I wonder, and maybe someone there is able to answer this question, whether our technology infrastructures from the engineering mind are going to change or be different based on the jurisdictional infrastructure and how the laws are already implemented, and whether the structure for blockchain will be simply working differently in the United States than in Switzerland or Denmark? I don't know the answer. I just, maybe more questions than answers, but yeah, thank you.
Part of what you were talking about was sort of in between sort of corporate governance and sort of like considerations around sort of financial probity, and so that pivots nicely to I think what Brian has expertise in, having been counsel in a financial services firm, as well as looking at some of the corporate stuff. So Brian, please take away.
Thanks so much, Tony. And again, pleased to be here. I'll give you a warning. It's now 6:48 in the morning. My body thinks it's 6:48 in the morning. I haven't slept tonight, okay? So later on I have to see whether I actually spoke in English or another language. So by way of brief introduction, I'll share with you a little bit of my journey, and that will perhaps understand where I'm coming from. And I think it links nicely with what others have spoken about here. And maybe that'll provide a linkage to questions that you may have, because there are so many things that we can talk about here. So my background, I was a corporate lawyer. I worked at Sullivan Cromwell in New York, and during the dot-com boom, came here to do dot-com IPOs. That shows my age here, right? And so for those that don't know, these days I say, well, that's where the SEC chair comes from, SNC. So that shows perhaps some of my conservatism around this. Then I got headhunted to join Credit Suisse in Hong Kong, so we've basically worked on IPOs across the whole region. So exposure to U.S. capital market, securities laws, but also securities laws around the region. I left a few years ago to enter startup land, and I focused on the area that I called online capital marketplaces. That was after the U.S. had the Jobs Act, so equity crowdfunding, and then P2P, and then that's what led me to blockchain and crypto. Now, these days I spend more time in a few different capacities. So one is in RegTech. So if you think about RegTech, it's using blockchain. How does RegTech apply to blockchain, and how can you use blockchain? And by blockchain here, for now, I use blockchain and DLT interchangeably, so I do mean both, right? Blockchain, DLT, how does that help as RegTech? So on the side, I had also set up a social enterprise called Young Makers, Change Makers, and which is basically a educational platform, a STEAM educational platform. So we're teaching kids from 10 to 18 how to code. And ideate, prototype, create apps that address the UN Sustainable Goals. I was sharing with Michael, I had UN SDG projects there. So I came back into the law early last year when I heard about this thing called Global Legal Hackathon. I said, wow, that's great, lawyers, hackathon, yay! Who's going to organize it in Hong Kong? Mm-hmm. Nobody was organizing it, so I said, fine, I'll do it. And I did it together because Thomson Reuters covered the bills. And so we did the first, so I added a law tech and reg tech hackathon, and our top Hong Kong team made it to the finals in New York, and they won there, which is great. It was an access to justice project. And I guess as a combination of these various things, I got tapped by Hong Kong U. So Hong Kong U said we wanted to start a new initiative and would like you to lead it. They like acronyms, so I called it LIGHT, Law, Innovation, Technology, Entrepreneurship, which means you can put a lot of stuff into it, right? So part of it is linked to education and the future of lawyers and how they are trained. Law permeates everything that you do, right, in all startups. And whether you think about blockchain or think about shared economy, there's law in all of this. And therefore, and these are cutting-edge questions that the earlier you get lawyers involved, the better. By the same token, the lawyers need to understand the technology, as you're indicating, right? So how do we put them together? And so with Light Lab, we've done a few different things. We've had a global blockchain and DLT leadership series where we're focused on digital sovereignty and on smart contracts. So we've had Sovereign, CTO present there. We had Charles Hodkinson from Cardano and Ethereum co-founder present there. Just last weekend, I organized a smart legal contract challenge. And so we had a room like this, about 80 people coming together, learning about open law, again, another Ethereum and consensus project, and clause, and then they were building stuff. And some of the interesting projects that did come out of that, I had a GC from a local television company that wanted to use blockchain for licensing, right? I had others who wanted to do tokenization of art, and yet another one that wanted to add IoT to smart contracts, so we're really discussing the Oracle issues. So these are some of the cool things, but coming back to this topic of enterprise, so I wrote a couple of points here just so that my mind doesn't wander too much. I think the first thing to discuss, which I'm surprised hasn't been discussed as much as yet till now, is the difference between permissioned and public, right? So if you want to talk enterprise, and big companies love blockchain if it's permissioned. There's some countries around the world love blockchain if it's permissioned. I'm in Hong Kong. In China, tokens are illegal, right? So I was sharing with somebody, I chaired a panel once, and I had a Davis Polk lawyer next to me, and I said, okay, and then I had the head of Gibraltar Stock Exchange here, and then somebody from EY. And I said, well, it's easy. For out here, we exclude China and we exclude the US. So we don't have to worry about the intricacies of the US securities law, right? Which I'm fairly familiar with, but, we didn't have to deal with those intricacies, right? And we really are at the forefront of what was talked about earlier on about regulatory arbitrage and the types of projects that are coming out. Then you've got, of course, the public. And then so within the permissioned world, you have lots of really cool projects that are coming to bear, right? A lot of them are consortiums, as had been mentioned earlier on. You've got a lot of, and a lot of them, like in China, it was just announced a couple of days ago. If you didn't already know, China has the largest number of blockchain patents in the world. And arguably, according to this particular count, quite a large number, shall we say, of blockchain projects. But they're not kind of blockchain projects we're talking about here. These are all permissioned with regulatory nodes, so what I call, with Chinese characteristics, right? So you've got those projects happening, and in Asia, trade finance is one of the largest enterprise use cases of blockchain, and we've got representatives from Singapore here. So Singapore and Project Ubin has done tremendous things in relation to blockchain projects. These are real solid blockchain projects, right? And they're pushing ahead in out of Hong Kong, multi-jurisdictional trade finance initiatives. Now, in the public space, we talked about the law aspects, and we can really geek out about that. But generally, what I share is that there are two main areas that lay people focus on. The first is securities law, right? And yes, that's important. I'm surprised. This is one of the first blockchain events I've attended in a while that hasn't used the word STO, right? Everyone loves an STO, securities token offering. But what does that really mean, right? And linked to the earlier point, also by Alexandra, you might be surprised, or maybe not, to note that the first STOs are really with respect to venture funds, crypto venture funds, right? And to me, it made sense when I thought about it, because it deals with the governance issue. But more importantly, the venture funds, the founders have to pay lawyers anyway to create the fund. So they just pay a little bit extra to tokenize it. Whereas if you want to do a tokenized real estate, you need to start from scratch. So your investment really is quite high to develop those standards around that. So there's a securities law aspect that has been touched upon. We can speak about more, but the other one that was touched upon in the early panel too was the AML KYC element, right? So to me, while securities law, there is still a difference in different jurisdictions, AML KYC is going to get standardized. FATF has now come out, and if you're not familiar already, the new phrase is virtual assets service providers, and that's going to apply across the world. So in some ways, that arbitrage element is going to be more limited. I want to end with a few other thoughts. So I recently gave a talk about the application of blockchain in the legal sphere, and I kind of identified three main kind of uses for you to think about, especially since the topic here is enterprise legal communities, which I presume are in-house lawyers and like. So the first is on automated and smart contracts. So what can be automated and in what circumstances, and what are their pros, and frankly, what are their cons and limitations? The second is in records and registry, right? This is the immutability element. So what would be really beneficial, and you see this increasingly in some GovTech type pilots in terms of real estate and the like. And then the third area is in virtual assets. So there you have the concept of the tokenization, but also really it's about economic incentivization in circumstances that didn't previously exist. Now, as for the limitations in terms of more of the enterprise legal community adopting this, I echo Silke in relation to skills, right? Skills and mindset, right? So next week when I go back to Hong Kong, I'll be speaking at the Associated Corporate Council annual meeting in Asia Pacific, and they now have a legal tech and innovation stream, right? So they are trying to get their arms around this, but a lot of it is about skills and mindsets and the fear that, oh no, AI especially is going to take over my job, right? Then comes the issue of liability. It's, does this all work? And just to finish off, as lawyers, I joke, when we draft, that's why we have dispute resolution clauses. We can't draft a foolproof contract, right? And we know we're not covering all the contingencies. So the liability issue still needs to be grappled with in terms of what if the smart contract doesn't actually work the way you think it will work. But there are mechanisms around auditing and different aspects coming through. So let me leave it at that, Tony.
Thank you so much. I just want to ask one question, and I'm going to open it up. But this question relates back to what Mark was saying earlier about the notion of co-adaptation. And so, Silke or any of you, to the extent that you want to see in-house lawyers and enterprise counsel sort of leaning into that co-adaptation, and if they're taking a legal absolutist position, then they're really not potentially being that helpful to their business and technical colleagues. How should they reasonably go about doing that, given their sort of risk hats and their legal training, but to sort of try and move towards that co-adaptation? Do you have any advice or thoughts on how to go about that? Any of you?
I generally think the issue with that is that you have to take a lot of risks. You're very much in the gray area, and your lawyers do not have a full answer, or do not have any answer. And in the end, you actually the one who have to take the risk. So I think to one advice is, well, you do have to take the risks. That's what I would say about that. And second advice is, I generally think I have, as internally at Gnosis, we got a lot of help, if that answers your question, from different kind of lawyers or even jurists in the space. So sometimes, actually the advice of a university professor would be really, really helpful because they're just thinking in a different way. Another issue is, of course, you always have to talk to the regulators, and often it actually helps to speak to the regulators, not through your lawyers, but directly to them. And internationally, there are now a lot of fora where you do manage to speak to regulators, and you have workshops together. For example, we are trying to be regulated at the moment in Gibraltar. So while the prediction markets is legally a very difficult topic internationally, we speak earlier about the Gibraltars and those small jurisdictions, and that they won't make a difference in the end. I actually think they make a huge difference because they bring something out. And so they are very versatile, and they actually speak to you. They do workshops where you come to a common ground and you find a solution. So actually what you need is someone who, it's like I think in the end, and this is related to the automation point, and maybe I go off topic now, but in the end, you end up not having transactional lawyer very much anymore. I mean, if you look at a very extreme model of that, you have basically only like lawyers that deal with compliance and give advice, and dispute resolution or dispute lawyers that resolve disputes basically in whatever capacity that is. And I think that's what the legal profession will be in a few years. So you said about, everyone is worried about, or like some people in the space, lawyers are worried about losing their jobs. Long term, I think they will lose their jobs, but there are other jobs, and it's more focused on dispute resolution and thinking outside the box. Does that answer?
Maybe if I can add to that. So I think so we've got two experiments going on, right? This is a new area we're all experimenting. So the first is what I kind of call a hackathon approach. So with the hackathon, actually my hackathon, so I just ran for our second year the what I now call Legal Reg Tech Hack, right, in conjunction with the Global Legal Hackathon. So we actually had, and I totally agree with that, it is bringing together the whole ecosystem. So we're lucky enough to have, 6 international law firms as sponsors, plus Thomson Reuters. We had the Department of Justice as a judge. We had the head of the Corporate Counsel Association president as a judge. We had Securities and Futures Commission as mentors, and we had the HK, Hong Kong Monetary Authority, which is basically the Fed, as observers there. So we want to bring the whole ecosystem together, and the only way I think that in-house lawyers can do it, and our winning team this year was led by a lawyer from UBS. In-house lawyer, she went to the hackathon. I call it the hackathon magic. She went alone, she had an idea, she pitched it, she got a team, they prototyped it, they created something, and they won, and last week they were just announced as making it to the finals in New York again, right? So to me, and this is an in-house lawyer from UBS in private banking, right? So this can happen, and by sitting down, she realizes all the things that are possible with technology, and by the same token, the technologists can say, oh wow, this legal stuff can be quite interesting, right? And so they're creating solutions for that. So that's the first aspect. The second experiment we're trying out, I call it Lexi. So Lexi is our law tech and reg tech incubator. So the idea there is that we see a lot of these companies coming out in this space, but how do we grow them? And we grow them by doing an incubator, but really being vertically focused. We are not technology, we're technology agnostic. And again, I want to touch upon that point because I think that's a lot of regulators and legislation, legislators are afraid to be too technology specific as they do legislate. And you understand this, right? Because this will change. I mean, with DLT, that's the new, so I work with some DLTs which are not blockchains. So if you just regulate it for blockchains, then, you've missed a lot, right? So, so with Lexi, the idea is to be focused on the vertical, but we're bringing together lawyers and students and technologists, and we're helping them grow in this particular vertical. So we welcome anyone who's developing in that space because we want this, as you say, to be a community. We have no boundaries here in terms of geography and the like. Let's all build together.
Well, if I understood the question, it was partly how do you get internal counsel that may be more conservative and risk averse warmed up to, and then maybe catalyzed to start to be not obstructionist, but how-to lawyers, and to help navigate with their clients, the enterprise, toward the next generation of technology and business models. So I'll just some basic stuff. But one thing is, if the company has a lab, and some still do, many more used to, it's a great place in-house to start to experiment with the stuff and include lawyers on the team. If there's at least a CTO, they may be willing to incubate some projects. And I think the trick, and then if there isn't that, then you're probably a member of trade associations at least, where there may be, where there almost certainly is, some working group or some place where they can experiment with the technologies. I think for experimenting, having lawyers on the team that are setting up a kind of a use case or proof of concept along with the business people and along with the technologists, of course, business, legal, technical, like BLT, is the right way to get them all together so that they're understanding what is the business model, what's the legal framework, what's the technical architecture, how do they fit together, and what are we evaluating, so that when you get something back, they can have a reasoned basis and a way to do a risk assessment and a kind of a revenue and cost projection. I think 3 things that are worth evaluating when they're more conservative folks are looking at this stuff for the first time are value, readiness, and fit. So, like I think you had said, what is the value is one of your criteria. You know, that almost goes without saying. The business value primarily. Readiness is, you know, where is it if you have a CTO especially thing and say, well, where is this on the sort of maturity curve for these technologies, and you know, how much can we rely on it, and how ready are the vendors to support it, or everything else? And fit, what's the fit for our entity? You know, are our people ready for this? Are they trained for this? Can we support this? Those are 3 real good questions to ask in an enterprise evaluation phase for this type of technology. These are questions I've guided big enterprises in asking, and it's been productive. And then the last thing is just to get them talking, at least, and thinking. I think having a quadrant is a good conversation starter for understanding the ecology of these technologies. And on the quadrant, on one extreme of an axis is permissionless. On the other extreme of that same axis is permissioned. On one extreme of the other axis is public, and the other extreme is private. So you could then talk about something like a Tendermint or like a Hyperledger Fabric implementation that's totally private, no one can see it but the authorized people with the thumbprints, and it's completely permissioned. And you can start playing with the curves of, well, actually, some things we actually want public, but only certain people can write to it. And you can show every permutation and then gradations of those so that they can see that they can engage in a somewhat more creative legal engineering or like a legal architecture, design-oriented conversation. And also they can start to map things they understand to the new technology and ask the right questions. So those are some of the best of in my toolkit of how to warm these people up.
Thank you. Does anybody else have questions for their panel? No, I'm going to, yeah.
Just from the practical point of view, Sylvia, have you come up with some kind of solution on how to train lawyers that can work with blockchain? Because we were experiencing same problems, and what I came up with is that you hardly can teach a horse bark, but you technically can try to teach to make the dog pull the carriage. So the way around, the way around could be taking technical professionals like mathematicians, blockchain code professionals, and try making them learn the law, and that would work better than making lawyers learn to code.
Yes.
Well, so
You should get one of these mics.
yes. I think if I may answer to you on this, I think it's both ways. So in our company, how we've dealt with the lawyers and in my team is basically we have an onboarding process, and this has worked so far quite well. It's pretty technical. And they're quizzes related, and lawyers are very competitive. So you make these lawyers do this like onboarding process, which involves all like this smart contract stuff. Inevitably, they're not going to be as good as the technical people, but they tend to be competitive. So they try it, and in the end, some of them will be able to pass it. Some others say, "Sorry, I'm a lawyer. I can't do with this. Can someone please help me with this?" Then I think on the other hand, we also have legal sessions for all the people who work as programmers, mathematicians, because they're building all this stuff, and in the end, the legal department will tell them, "Sorry guys, this is really not going to do this. This is not possible because of this and this and this regulatory." So it's a both. I mean, this is maybe a co-adaptation way. I also think that these online courses like Udacity or even here or like Coursera, they have great courses for people to start start a little coding, for example. So there are nano degrees for people, for lawyers, and I mean, if you have to, you do it. We all passed, first or second, third grade math, so we'll also pass first or second or third grade coding, and it's like, I mean, companies, we're not DAOs, so you can force people to do it.
So on that, we're running slightly over time, so I want to give a warm thanks to our panelists. Thank you very much.